Okay, welcome back. Our next panel is a really interesting one on managing internal investigations and advanced government defense. And we have a really terrific panel, starting with our moderator, Ed Westerman. He's a senior managing director at FTI Consulting and co-leader of the risk and investigations practice, also leader of the firm's Global Investigations Initiative. In addition to working for companies and boards of directors, Ed has worked for the SEC, DOJ, California DAs, you name it, in the federal and state government world. He's a certified fraud examiner, also a CPA with more than 20 years experience in forensic accounting investigations. So he really is an ideal person to lead this panel. Welcome, Ed.
Thank you.
Next, I want to introduce Craig Martin. The panel benefits from his perspective as a seasoned SEC enforcement defense lawyer. He's a partner at Morrison and Foerster. He represents directors, C-suite executives, public companies, audit committees, regulated entities, and lots of others. And he's also served for over 3 years in the enforcement division himself. But Craig's, his experience with financial matters, especially with internal investigations, really makes him a great fit for this panel. Welcome, Craig.
Oh, thanks, Bruce. Glad to be here.
I next would like to introduce Leslie Caldwell, partner at Latham and Watkins. Leslie was actually our keynote speaker back in 2016. Thank you again for that, Leslie, when she was the Assistant Attorney General of the DOJ's Criminal Division. Her illustrious career as a prosecutor also includes time as an AUSA in both the Eastern District of New York and the Northern District of California, as well as being head of the Enron Task Force. And now she's at Latham advising companies and executives and boards who are facing crises or government investigations. And she can offer a really unique perspective on this panel. So thank you again, Leslie, and welcome.
Thank you. Thanks, Bruce. Thanks for having me.
Finally, from the SEC, I'm always delighted to welcome Alca Patel. Alca began working in the LA office almost 20 years ago as a staff attorney and became an assistant director in 2009. She has served as a member of the Enforcement Division's FCPA specialized group since 2010. Alka has investigated and litigated a real broad spectrum of significant matters. And now as an associate director, together with Kate Zoladz, who you'll hear from later today, she oversees the office's enforcement efforts in Southern California, Arizona, Nevada, Hawaii. So it's terrific to have Alka with us on this panel. Alka, thank you so much and welcome.
Thank you, Bruce. Glad to be here.
All right, let me turn it back over to Ed. Thanks, Ed.
Yeah, thank you, Bruce. Welcome, everybody. In order to make our panel on the topic more relevant to today's securities markets, we're going to do a short case scenario that's SPAC-based. So I'm just going to give you some background on the case study, and then we'll launch into the panel discussion. So here's the facts. We've got a young technology company that went public 2 months ago, became U.S. listed via a SPAC or de-SPAC transaction. A short seller report was released last week alleging 4 things. 1, the company's analytics platform, which is licensed by healthcare providers and payers, isn't anywhere near as advanced as was disclosed prior to going public. The short seller report also alleges the company's analytics platform is causing millions of dollars of overcharges to health insurance payers, including the federal government. The company's public revenue projections were extremely rosy, but in fact, management had developed more likely scenarios that would have yielded only half the revenue and growth, but those did not get publicly disclosed. And finally, the CEO of the company had a prior SEC enforcement action where he was previously employed by another publicly traded company, and he paid several millions in settlement costs, although our board was already aware of that as part of doing their due diligence in hiring him. Okay, so to kick this off, Leslie, let's start with you. The chairwoman of the audit committee gives you a call. She wants to get your advice on whether or not the audit committee needs to launch an independent investigation. She thinks there's no merit to the allegations. And just like other short seller reports, this short seller is simply trying to profit from quote unquote false information. So Leslie, what factors are important considerations for an audit committee in deciding whether to proceed with an investigation or let management handle it, or just hope all this, gets out of the press and goes away?
Hoping it all goes away is never a good option because it's probably not going to go away. On the other hand, I think just merely receiving a short seller report or seeing a short seller report that was released is not necessarily enough to launch, certainly not to require the launch of an audit committee investigation, because short seller reports are out there all the time and may have value, may have validity, may not, but I don't think that alone would be a basis. On the other hand, if true, the allegations are fairly serious, so they should be taken somewhat seriously and at least explored. Maybe not necessarily by the audit committee, but maybe initially by somebody in the general counsel's office, if there is a general counsel or management. It doesn't directly implicate, other than the fact that the CEO had a prior SEC resolution, which in itself would make, I think, most audit committee people a little bit nervous. It doesn't really raise specific allegations about the CEO personally having done anything wrong. So I think that this alone is probably not enough to launch an audit committee investigation, but it's certainly something that would warrant kicking the tires and seeing if there might be something to the allegations.
Okay, great. So she says, thank you very much. She gets the GC involved. The GC starts doing some work. And then let's just say while that work is happening, 1 week later, all of a sudden an anonymous whistleblower letter lands in the lap of the audit committee chair, alleging some of the same issues contained in the short seller report, including an allegation by the CEO. Craig, did that change the calculus?
I think so. Anonymous letters like short seller reports are fraught with anonymity, your ability to really confirm the accuracy and credibility of that letter and the accusations in that letter is quite limited. But that, coupled with the allegations in the short seller report, would move me and probably most audit committee chairs to concluding that an investigation is probably warranted. Unless the letter is written in crayon, it's probably enough to push you over the edge.
Okay, thank you. And Alka, as the SEC enforcement representative on our panel, let me ask you, in general, how much attention does the SEC enforcement division pay to short seller reports, especially given the financial incentives that short sellers have?
So first of all, let me just, the views I expressed today are my own and do not necessarily reflect the views of the commission or the commission staff. Every year we get thousands of tips and complaints from the public, and many of which translate into enforcement actions and many that don't. We follow the news just like everyone else, and that's just another source of information for us for opening new investigations. So we look at class action complaints, 8Ks, press releases, and also short seller reports. So we don't necessarily place more significance on one public source over another. Just like everything else, some sources are better than others, and we can sometimes get a tip from an extremely credible source, and yet it may not pan out. So in our experience, some short seller reports have proven valuable and others have not. So our analysis and approach in evaluating the merits of the short seller report would be the same, though, whether it involves a SPAC or a public issuer or a private company or anything at all.
Okay, thank you. So let's assume that Leslie and Craig did a great job talking to the audit committee chair. Based on this information, she decides to go ahead and wants to, hire both of them and launch an independent investigation. And so she's asking, well, what are the next steps? But she reminds Craig that the company is headquartered in Canada, which is still subject to a strict lockdown due to COVID. So, Craig, let me just start by asking you, how did you adapt in conducting your investigations since COVID has hit? And how much of those are remote, versus, the old days of what we used to do in person?
Yeah, so virtually every aspect of internal investigations over the last year has changed very significantly. Both, starting with data collection, we were able to do a surprising amount of data collection remotely. There were inevitably aspects of a document collection that needed to be handled in person. So, for example, identifying and collecting hard copy documents that may be back at the office or more likely sitting at home with a witness. But our collection, processing, review of documents was almost entirely remote. Similarly, the types of witness interviews that we did that normally would be in person, ranging from relatively minor witnesses all the way up to and including executives in the C-suite, those were handled remotely as well. We found ways to get documents in people's hands in advance of interviews where that was appropriate. We found ways to show documents on screen and question witnesses about them. And then we found ways to brief our clients without meeting in person and not seeing each other for the entire in person for the entire course of the investigation. So it was pretty much cradle to grave, all aspects of the investigation being handled remotely.
Okay. And Leslie, anything you want to add to that? Any best practices for attorneys for conducting investigations in a remote environment?
So I think it's, I know that at first, we, including me, were all alarmed by the notion of having to do interviews over Zoom, where you couldn't see the person across from you and you couldn't see their body language and you couldn't use all of these things that you think you have to sense whether someone's lying or not, or whether someone's leaving something out. But I was surprised how quickly we adapted and frankly, how very close to live in-person interviews the Zoom interviews can be. And I think, you just want to make sure that you've got, to the extent you've got folks who are putting things up on screens and sharing screens, that you've got that all lined up in advance so that it's seamless during the interview and you're not distracted by technical challenges. But I've been surprised at how seamless it is at this point, and we're kind of all used to it. And I wonder whether we'll ever go back to having to get on a plane to name that country or name that city to do groups of interviews, particularly for less important witnesses.
Yeah, I was actually going to ask that question. So, Craig, I'm curious. I mean, now things are opening up. When we go post-COVID, to what extent do you foresee that we're going to go back to the old ways of doing investigation?
I agree with Leslie. I think that there are many lessons that we learned here that are going to carry over post-COVID. And I think it's going to be driven less by the sorts of natural concerns that we had about, as lawyers about assessing credibility, and more by the efficiencies of, is the company headquartered here? And is it a short drive away? And if so, having witnesses come to us or us going to witnesses will make a lot more sense. It'll be more efficient. But I agree, particularly for less important witnesses who are in far-flung locations, I think Zoom interviews are here to stay, and I'm perfectly fine with that.
Okay. And Alka, let me ask you from the SEC enforcement perspective, what did enforcement do to adapt, or were there improvements made to the SEC's investigations processes that came as a result of COVID?
So it was obviously challenging for us, just like everybody else. But I think we had a little bit of a leg up, because even pre-COVID, the enforcement division was already operating somewhat paperless. And we already had extended telework. So it was somewhat of an easier transition. So that helped us in allowing us to continue doing what we were already doing, and it also helped us take on new investigations that were COVID related. And in fact, during the past year, we filed a number of contested actions, including emergency TROs. So it was a kind of business as usual, but with a little twist. And during this whole time, I think we've been doing, just like Craig and Leslie said, a lot more, obviously, remote testimonies and interviews, and we're getting better at it. It was challenging, of course, in the beginning. We've also incorporated new technology in our operations. We've had success with attorney proffers and responses to interrogatory type of questions, and that has helped us get information quickly and also streamline our focus when appropriate. And then Wells meetings have been good as well. We've conducted several of them during the pandemic, and they work very well. Council has been able to show documents, highlight key portions of testimonies or whatever else they want to highlight. And everyone has saved a lot of travel time, and scheduling has been a lot easier for these meetings. So overall, it is working. It's different than what it was before, but certainly everybody's getting used to it, and it's just become like the new normal.
Yeah. And I will say that, from the outside looking in at the government's response here, it was it was interesting watching them come up the curve and not speaking specifically about the SEC, but where we had virtual meetings that, early in the pandemic with multiple government organizations, watching them try to navigate their own internal policies about which of the video conferencing systems they could use, which were considered secure. In one matter, we ended up defaulting to telephone because the various agencies had different requirements that they were required to observe in having conferences with us. But I agree with Alka that as time went on, they got quite adept at virtual meetings.
I do think that there's one area that is certainly in my practice that is still a little daunting to do virtually, and that is, for example, having your individual client be interviewed by either the SEC or the DOJ. It's very hard for your client to feel comfortable if you're not in the same room as them, and honestly, it's kind of hard for the lawyer to feel comfortable when they're not in the same room as the SEC or DOJ attorney. So I think that those in-person meetings, whether they be proffers or testimony, there's a lot of value to having that in person for everyone involved, including the government.
Yeah, that's a very good point. Thank you. Okay. So let me move on to another issue, which is, when and how do you inform the government about an internal investigation that's been launched? So in our scenario, the audit committee chairwoman doesn't want to issue any public notice or inform any government bodies that an investigation is being conducted. And she asks you, Craig, well, when should the company go public with the statements on that?
Yeah, so in terms of going public, I interpret that question to be, when should we issue an 8K? And, first of all, I've had this conversation with audit committee chairs, and I have reminded them that of what their role is. They're the audit committee chair. They're not disclosure counsel. They don't even have disclosure counsel typically reporting into them. And so, this is typically a discussion that is had with the company's outside disclosure counsel, with management, and typically more broadly at the board level. With that being said, generally speaking, depending on the seriousness of the allegations and the stage at which the internal investigation is at, it may be entirely appropriate to keep this investigation confidential. While the company or the audit committee takes the time to better understand the facts and be able to say something meaningful, if indeed that ever becomes appropriate. Typically, disclosures to the public in the form of an 8K are driven by a public company's filing schedule. And so if the company has a 10Q or a 10K coming due, and given the pendency of the internal investigation, they're not going to be able to make that filing, either because they're not comfortable that they can make those statements, or because their auditors aren't going to be signing off with a review or an audit opinion. A company will then often choose to make a disclosure.
Okay, thank you. Alka, do you have any views on this? Do you agree with Craig? I mean, when do you think it's the right time to notice the SEC and the market?
I mean, it is certainly the company's decision as to whether it should or when it should inform the SEC about the internal investigation. But we always believe that it is in the company's interest to inform us sooner rather than later. First of all, when considering the charges or the relief, particularly in terms of civil penalty, the SEC will consider a corporation's cooperation. And as you know, the 2001 C-Board report details out the many factors that the Commission considers in determining whether to give cooperation credit and how much cooperation credit to give. So those factors include self-reporting, and the company's willingness to conduct an internal investigation and voluntarily disclose the results. So that's a good reason to self-report and report earlier. And then another reason is that, there's a good likelihood that we're going to hear about this from a whistleblower. As you've heard from the news, that we are giving out a lot of whistleblower awards, and we have our program is very successful. So more and more whistleblowers are incentivized to come forward and report the misconduct to us. So it's not great when we hear about these things from either from the news and not from the company itself. The other point I want to make is that the Supreme Court's decision in Digital Realty, which deals with whistleblowers and which held that for the entire retaliation protection, the whistleblower must report not just internally within that company, but also to the SEC. So that's another reason why more whistleblowers will likely report to the SEC. And that's something that I think the company and the audit committee should keep in mind when they make a decision as to when they want to report to the government.
Okay.
Ed, could I just add something about DOJ?
Yeah, I actually was going to ask you that, because I think having been at the DOJ, I think given that there's a short seller report, they're making allegations about overcharging the federal government. And should we be notifying the DOJ or not saying anything at this point?
So I think the issue of putting aside, most companies do not have any obligation to disclose to DOJ or to the government, putting aside the SEC, when they find some sort of fraud in their company. I mean, there are in our hypothetical, this company is involved in a business that affects government payments of medical insurance, presumably Medicare. There is a regulation that when a company finds credible evidence of a fraud or a False Claims Act violation in connection with the program, and once it's gathered up sufficient information to be persuaded that there is some there is an obligation, a mandatory obligation for some companies, if they have a contract with the government, to disclose what they found. That's a lot of layers of when you have to disclose. If you don't have those scenarios, no contract with the government, you generally don't have an obligation to disclose anything to DOJ. And I would certainly not counsel that a company disclose something as soon as an allegation is made, but only after there's some investigation done and there's an understanding that there really is something there. And I would say that if you're going to disclose the facts to the SEC, unless it's very obviously not trending in the direction of being a potential criminal case, you may also want to consider simultaneously or shortly thereafter disclosing the facts to DOJ. But I don't think, and I think there are two different bars, and the SEC and the DOJ have different bars. I'm not saying within their agencies, but in terms of calculating when you should disclose to the SEC, there may be accounting issues or other reporting issues that really don't rise to the level of something DOJ would be interested in. So you don't automatically want to disclose to both at the same time, no matter what the issue. But there are things that you're gonna want to tell DOJ when you think that that it's warranted.
Okay, that's super helpful.
And I totally agree with that. I look at the decision about whether A, to make a public statement as discrete from B, whether and when you're going to pick up the phone and call the SEC, which is also discrete from the question of whether you're going to pick up the phone and call DOJ. And then I'll throw in another very important constituency, which I know you're very familiar with, Ed, which is your auditors. The audit committee chair is going to, I think we're going to have a very serious conversation about promptly notifying the auditor about both the allegations as well as the audit committee decision to undertake its own investigation.
Hey, that's another very good point. Okay, thank you. That was great. So let's assume that my colleagues at FTI did some extensive data analytics of the case study company's transactions and found a couple $1 million of overcharges out of $100 million total payments. Is this a problem, Craig? The audit committee chair says, "Oh, thank goodness, this is not material from a quantitative standpoint." So, do we need to be worried about this?
Yeah. So possibly, it could still possibly. It doesn't sound like, Ed, under this scenario, that this is likely to trigger a restatement, which is great news for the company. You may, as Leslie was alluding to, have potential liability under the False Claims Act, and therefore, there may indeed be some need to report this and get square with the government. This may also have implications for the viability of our product. It may have an effect on important customer relationships. And so there are potentially some substantial, disclosure and or regulatory considerations that are going to have to be reached. Finally, turning back to the auditors, depending on what happened here, notwithstanding the relatively small financial effect, it may have implications for their view of the integrity of management, and so you may find yourself in a situation where the viability of the current executive team is called into question.
Okay.
Yeah, and that's absolutely true. Even if something is relatively de minimis in terms of quantitative materiality, if it implicates management integrity, can be a potentially very serious issue, particularly in our hypothetical where the CEO already has a history of an SEC resolution. And there's also another consideration, which is there some control issue that either there weren't enough controls to stop this from happening, or there were controls but they didn't work, and then the question becomes, why didn't they work? Was it because they just didn't work, or they were inadequate, or somebody deliberately circumvented them? So even when the amount is relatively small, you still have to factor in those issues.
Yeah, I think those are all great points. Thank you. So I want to move to something that's a very hot topic with respect to public companies that went public via SPACs. And so if you recall the facts in our case study, let's assume that we interviewed management and that management during the interviews said, yes, we did have multiple sets of revenue and growth projections at the time the company went public, but the lower projections were not publicly shared because management thought that they were not the most likely growth and revenue scenarios. And so, Craig, let me ask you, to what extent does this present an SEC disclosure problem? Should that information have been disclosed or not?
Yeah, well, Alka will know best on this, but I would start from the joint statement that Chairman Clayton and Corp Fin issued last year, where they talked about the importance of forward-looking statements, particularly in the context of the pandemic. They encouraged companies to make projections and to look forward based on any number of different financial criteria that weren't in and of themselves required to be disclosed. And they assured folks that that good faith efforts to make projections would not be second guessed. And it sounds like in this scenario, the company considered multiple potential projections of its financial performance and settled on one that in perhaps in hindsight turned out to be overly optimistic, but nevertheless at the time was adopted in good faith and on the basis of on a reasonable basis. So from the perspective of audit committee counsel, this is certainly something that we would have to dig into and understand, but in and of itself, I'm not deeply troubled by the fact that they issued a projection that turned out to be incorrect.
And Leslie, do you have any comments on that?
No, I totally agree with Craig. I think that just because there are multiple scenarios gamed out internally doesn't mean that failure to disclose the worst case of those is problematic.
Okay. And Alka, do you have a different view of that?
So basically, when we look at financial statements, we're not just thinking about whether the numbers are correct, but also are the disclosures accurate and complete. And forward-looking information is valuable to investors in their investment decision. But as we know, forward-looking information such as projections can also be speculative or misleading and even fraudulent. So when we conduct our investigations, we are always sensitive to potential half-truths and omissions that that depart from what is management's knowledge about the issuer's position. So an important, let's say, a objective of the disclosure framework is to allow the investors to see the company through the management's eyes. And this requires for us a case-by-case analysis and review of all disclosures to determine if anything is misleading.
Okay. So Craig, let's assume that when you call up the SEC and tell them that you're doing an independent investigation, that Alka says, well, Craig, are you aware that the CEO of the company had a prior SEC enforcement action against him? And how are you going to take this into account? And you convey that to the audit committee chair, and she says, well, to what extent does this have any relevance to the investigation at hand? Because, the board was aware of this when we hired him. We did our due diligence. We got comfortable. So why does this matter?
Well, so one reason it may matter is that item 401 of Reg SK actually requires disclosures of certain events that are relevant to an assessment of the executive's integrity. And those events include, in essence, entering into a consent decree or a settlement with the SEC involving an injunction. And so if that is not, in fact, referenced in the registration statement or the proxy or the 10K, I'm going to tell our audit committee chair that I expect Alka is going to have a real concern about that. But stepping back more broadly, audit committees have to take into account a lot of different factors as they're weighing the credibility of witnesses. Typically an audit committee chair is not going to participate in an interview. We have to describe both the substance of that interview and sometimes the demeanor of the witness as we're briefing our clients. And so I would expect that this prior experience with the SEC will inform or should inform both the SEC, both the director's assessment of the credibility of this person, as well as their viability going forward as CEO of the company. And then, of course, returning to our theme of the auditors, I expect that the CEO's history with the SEC is probably going to have their hair standing on end, and that will be, so that'll be a very serious conversation as well.
Yeah, I think that's right. I mean, as a former auditor and somebody who's been in the forensic accounting space for 25 years, I think you're right. I mean, especially if it goes to the integrity of the CEO or the CFO. And, if we have any conduct issues with them, you could have a situation where the auditors even resign if they don't feel like the remedial actions are appropriate in their view. So that's a good point. So let me just say, let's move to the conclusion of the investigation. And let's say that based on all the work that Leslie and Craig and the team have done, that the team and the audit committee found that certain allegations in the short seller report had merit and 2 executives of the company engaged in misconduct. So the audit committee, however, doesn't want to terminate the individuals because they feel that they are key to the future success of this relatively young tech company. And so instead, the audit committee thinks that there should be a reduction in their compensation and that some training should be provided to the 2 individuals. But the audit chair reaches out to Craig, you, and Leslie and says, well, what do you think regarding our remedial measures? Is that going to be adequate? What would you say? Leslie, do you want to start?
So unfortunately, this happens a lot where companies really don't want to take serious personnel action or maybe even any personnel action against important employees. And I think from the perspective, certainly of the DOJ, and I'll let Alka and Craig speak to the SEC, uneven consequences for employees is a real red flag about whether the company really gets the importance of compliance with the law. So if you say, for example, terminate salespeople for doing something wrong, but don't terminate the head of sales, who was their boss and who was in the loop on what they were doing because he's very important and vital to the success of the company, you won't really be able to justify that, certainly not to the DOJ, if he's engaged in misconduct. Having said that, the government, I think, recognizes, and it's appropriate to recognize, that there are gradations of misconduct, and not every single bad behavior warrants termination or severe consequences. So I think it would be very fact specific, depending on what exactly they did. If it was misconduct, was it deliberate? Was it in the face of warnings? It would really depend on the specific facts of the case. But certainly companies want to be careful that they treat employees with kind of an equal measure of what kind of discipline is meted out.
Anything to add to that?
I agree with that. I think boards will want to and can legitimately exercise their business judgment in deciding how they're going to discipline an executive. And one factor is, of course, business considerations. It's entirely legitimate for the board to consider the effect on the business of the discipline that they're considering meting out. They will also, of course, have to consider, as Leslie pointed out, and I bet Alka is going to say, that the remediation that they adopt will affect, will have consequences potentially for the company on the enforcement side, as well as, whether they're able to maintain their relationship with their auditors.
Yeah, okay, so that's a good point. So, Alka, let me ask you, if the audit committee's preferred remedial decision is to keep these executives employed, and that's exactly what happens, how does the SEC view that, and what is the SEC, what do they do if those people stay in place?
So from our perspective, I mean, the goal of an internal investigation is to get to the bottom of the issues, find the impact of the misconduct, identify the key bad actors, and take remedial measures. And that would include replacing the bad actors with new management. But I mean, I have to say there have been instances in the past where the commission has carefully tailored the relief in order to protect investors. So one example comes to mind is the Tesla and Elon Musk case a few years ago, in which the SEC sued them both for improper tweets by Musk. And the SEC's relief took the corporate governance changes. And even though Musk and Tesla both paid a significant penalty, $20 million, I believe, and all of that was distributed to the harmed investors, but Musk did remain in the company. He resigned as the chair, and then they added more directors and created independent committees to oversee his his procedures, his tweeting and whatnot. So, I mean, I think at the end of the day, it's a case-by-case analysis. Bottom line is investor protection.
Okay. So we're getting close to having to wrap up. But Alka, I did want to ask you something to get your take. You've been at the SEC a while. There's been any number of investigative teams and forensic accountants that have come in and made presentations to you. When those presentations get made, what are some things that you are expecting to hear and like to hear? And then what are the worst things that, an investigative team could come in and do during one of these presentations?
Yeah, so you're right. We've heard a lot of them. And of course, some presentations are better than others. But let me just say what we like to see. First, we like to get periodic updates rather than waiting till the end of the internal investigation. And then when they do make the presentation, we would, we obviously want to see that the findings are comprehensive. In other words, they didn't focus just on the narrow scope of the investigation that they started with, but as things got revealed and discovered that they expanded the scope of the investigation. We also want to see what role the individuals played. And then we want to see that the remedial measures are aligned with the misconduct. I mean, sometimes that doesn't happen. Sometimes the audit committee presentation will include a whole host of changes to the internal controls, but not all of them go to the detection or prevention of the issues that were discovered. So, those are some of the things. But I think one of the worst things that I've seen is when counsel will come in and tout the company's cooperation when in fact all they've done is essentially produce documents in response to our requests or our subpoenas. And if you're going to talk about cooperation, what we really want to see is what the company has done to investigation faster, make it easier, make it more efficient. So examples would be, do they share results of the internal investigations in real time? Did they bring in witnesses from abroad? Did they identify issues to us? Did they translate documents? Things like that. Sometimes the presentations just focus on what they produced, which are many times, as I said, things that we have asked for. So those are just some of the things that come to mind.
Okay, thank you. I'm taking notes right now, so that was great. I see Bruce is here. That means our time is up. I want to thank Leslie, Craig, and Alka. I thought this was a fabulous panel, so thank you. Thank all of you for joining our discussion today, and enjoy the rest of the program.
And Ed, thank you. You did a terrific job moderating the panel. Alka, Leslie, Craig, thank you so much. Our next panel is on financial disclosure and accounting fraud, and it'll get started at 11:50 a.m. So thanks again to the panel. We'll be back in just a few minutes.